us today, but welcome everyone. I'm Colleen Rowan, and along with Dominic Kennedy, we're launching what is now the updated version of the ADC-ICT manual. Dom and I edited it with a great deal of help from individuals at Vanderbilt University, who Dom, I'm sure, will discuss. I have to say at the beginning, though, that this is a very odd experience for me to look out into the vast cyber void, and I can't see any of the people I'm speaking with. So I hope you can see Dom and myself, and certainly as we go along, you're free to interrupt with questions or comments. However that works, Dom is much more astute at dealing with this aspect of a Zoom presentation than I am. So happily he's here to help.
So yeah, good afternoon, everybody. If you've got any questions, comments, or discussion points, at the bottom of the screen, there should be a Q&A box for you. And then you can put your questions in there and we can answer them at the end of our brief introduction.
Or as we go along, whatever works.
Yeah, whichever.
What we decided to do, Dom and I, was to break this up into two portions. I'm going to start out telling you a little bit of how it is that there is an ADC manual at all, which is a slightly scandalous historical story on the ICTY, the Tribunal for the Former Yugoslavia. I emphasize the word slightly. And then Dom, I think, will be providing you later with more specific information about the updates and why we did it and that kind of thing. I have to say that, at least in my opinion, and I've been practicing in the international courts now for about 15 years, primarily at the ICTY, that I believe that the ADC manual is still very unique, as is the ADC itself as a defense organization. And it's unique in that it's a manual that was put together and written only by people who had actually practiced law in the international criminal courts. They had practical experience. And the whole idea behind the manual, once it developed, was to have exactly that kind of information available to those who hadn't yet had a trial in the international courts, which is, this is the kind of structure you may run across. These are the kinds of legal issues you may run across. These are the kinds of practical problems that exist, and a whole series of other things. And of course, if you've seen the manual, which is available on the ADC website, you'll have a good idea of the kind of subjects that were covered. Now, the slightly scandalous story that leads to the existence of the ADC manual was that years ago, I believe it was 2009, the United Nations, along with a number of other organizations, decided that it would be a good idea to create a manual about the ICTY so that people would understand what the organization was about, how it was structured, how cases were brought in, how they were tried, and a series of very, very practical overview of how this organization functioned day to day. And I actually have this manual, which I dug up in my library. I don't know if it's exciting to see it or not, but it's the ICT Manual on Developed Practices. And it was prepared in conjunction with UNICRI, with OSCE, and with the War Crimes Project, which was going on at the time. And the original idea was that the defense, as part of the tribunal, would contribute a chapter to this manual that would describe essentially what it was like to function as defense counsel at the tribunal, the kinds of issues that were unique to playing that kind of role, and other kinds of topics similar to that, all related to the defense. And I was asked if I would please write this chapter, which I did. One of the issues that occurred at the tribunal, probably still is occurring in all international criminal courts, at least from the defense perspective, was that we were very concerned that we often got disclosure in our cases very late in the day. We would get disclosure while the trial was ongoing. We might get disclosure when a witness had already testified, and we would get disclosure, potentially exculpatory information about that witness, when essentially it was a little too late, very often too late, to use it effectively or investigate it effectively. So although my chapter wrote about many things about the defense, it did mention this issue. And after I had submitted it, I got a very, very polite email from the Office of the Presidency of the ICTY explaining that the work on the chapter was appreciated, but that the prosecution's office, the Office of the Prosecutor, which we call the OTP here, that the OTP had objected to this chapter being included, particularly because there had been some criticism of disclosure processes, and that rather than editing the chapter, they had decided to simply exclude it. So in other words, we were going to have the ICTY manual go out without any independent input from anyone from the defense side of the courtroom. Now, UNICRI, which was one of the main projects that was in support of the ICTY manual, had been having meetings in Sarajevo. I had attended some because I was going to be doing a chapter. And when this happened, they approached me and asked me if maybe what we could do instead of just a defense chapter for a manual was to create an entire defense manual all on its own, which is what I call a silver lining to a cloud, because for a while we were all a little bit distressed that there would be no defense chapter. And as it turned out, we ended up able to create an entire defense manual. The thing about the manual that I find unique is that it is created only by practicing lawyers. And in the context of its creation, and what I recall from those days, were literally lawyers running down from court, still wearing their robes, coming in with drafts for their chapters, participating with each other, a real sense of community and cooperation that went into the creation of this manual, and I think ultimately led to its success. There are other manuals in existence, obviously, everywhere that talk about criminal cases, the criminal law, international law. Obviously, those kinds of publications exist, and there are a lot of them. I still maintain that the one that the ADC was able to create is quite unique. Of course, I have a copy of that one here too. This was our original one. I don't know if you can see it that well, but this was the original one. It came even, and I'm not sure if I still have it, it came with a CD in the back, which included written motions on various topics that come up in ICL criminal trials that had been submitted by defense counsel at the ICTY. So it was very practice oriented, very much directed to solving practical problems, very much directed toward giving people an idea of what it was like to walk into The Hague from some foreign country, whatever one it was, unable to speak the local language perhaps unfamiliar with all the languages at the tribunal, no office, you don't really know anyone, you're meeting your client, okay, how do you start out from day one and make an effective defense, create a team, and then create an effective case when you actually go to trial. At the moment, we also did this, by the way, with, as always, a relatively minimal budget. We had a fair amount of time, but not a lot. And again, my hat is off to all the lawyers who participated and contributed to this. They really sacrificed time and took time out of their lives to try to create a quality product for those who would be coming in the future. Now, at the time, the manual was published in English and in Serbian, Croatian, Bosnian. We had a small production in Albanian, although I think those are distributed among a handful of lawyers in Kosovo. No, I'm not sure any of us have access to them anymore. There were only a few because there were only a couple of Kosovo cases at the ICTY. At least that's my idea of why there was a smaller translation there. However, I found out randomly at a conference that was being held in Italy for entirely different reasons on different topics. Someone came up to me and said, do you realize that your ADC manual is being used to train lawyers in Africa? And I learned later it was being used to train lawyers in South America. So it's wandered the earth in its various forms, and I think remains a unique practice manual as much as the ADC remains a unique, effective defense organization. And so I guess both Dom and I, and also everyone who's ever been a member of the ADC and worked with it, is extremely happy that we have now finally been able to update this manual, make it more effective, more updated in terms of the law. And with that, I'm going to turn this over to Dom, who has more information there, and take it away. And also happy to answer questions at any point.
Yep. Technical. Yep. Yep. So, am I appearing on video? I can't see myself.
I can see you.
I guess I can now. Yeah, so as Colleen's explained, like this started back in 2009. I think I came into it at the end of actually about 11 years ago. Wow, 11 years ago this week. I think we eventually launched the original one beginning of 2011. We started with the update, I think, as far back as 2014-15, and it's been a long ongoing project. But the aim was to include the jurisprudence from the other international tribunals. Because, as Colleen has explained, the first one was part of the legacy project for the ICTY, and only had ICTY practice and jurisprudence. So going through all the jurisprudence in the intervening years, of course, took a long time to make sure the date it was published, it included up-to-date information. As Colleen said, the aim of it was for defense practitioners worldwide. And I know, as Colleen said, South America, Africa. I also know from personal experience, Guantanamo Bay lawyers have been using this manual as well. And it really is practice orientated. The update we could not have done without a lot of individuals that gave the time pro bono basis. And especially, as Colleen briefly mentioned, like to Professor Mike Newton, who I think is joining us today, for the students from the International Law Clinic of Vanderbilt University, who spent a lot of time, and without their help, we simply wouldn't have got this published this year, especially in light of the pandemic. Like, we managed to get it out. The one thing that we did add a whole new chapter on contempt proceedings, which, as everybody might know, is something that's becoming more and more frequent in the international courts. And we just felt that this was something that needed to be, the peculiarities, especially between the, ICTY, the mechanism, and the International Criminal Court, was something we needed to highlight, especially with the complexity. For example, at the minute, we've got the Turnerbo case at the Arusha branch of the mechanism in The Hague, which is 6 accused. It's been ongoing for just over 2 years and it's going to go way into 2021. So the differences between how it's done at the ICC and the ICTY, where ICTY used to be short proceedings, and nowadays, yeah, as I've just said, 2 years long contempt proceedings. So that was something that was a complete new addition to the update. But
can I add one comment on the contempt, Dom, without?
Yeah, I know what you're going to say, but go.
Oh, no. Go ahead.
No, take it, go.
I mean, the one thing that actually the Vanderbilt people, in assisting us with this, did a beautiful job of highlighting was that, and this is odd in a contempt proceeding, at the ICC, contempt proceedings, for example, against defense counsel, are brought by the prosecution only, and that's by statute. This is peculiar among the ICL courts. Normally it would be a judge who brought that kind of proceeding, or once it was brought, there would be an independent prosecutor or an independent amicus appointed to prosecute that contempt proceeding. That's not true at the ICC, and it's led to some interesting developments and concerns in the Bemba case, and hopefully that will be the beginning and the end of it, but that's also in the contempt chapter. I just wanted to add that one little nuance.
Thanks, Colleen. But as I said, the update, as well as the original one, was intended to be practice orientated, especially to provide creative thought for those about the role and purpose of defense in mixed and civil law systems, which are utilized in many domestic and international criminal courts. It's not an exhaustive review of such practices, but it's intended to alert defense counsel as a starting point and provide them guidance with the different practices between the different international courts. The ultimate goal being the effectiveness of defense practice in all courts that are trying war crimes, crimes against humanity, genocide, whether on an international or domestic level. We decided it was going to be published in electronic form only, one, for funding reasons, and secondly, to be available to as many people as possible, and it's completely free. It's a one-of-a-kind publication that practitioners around the world, as you've heard, are using, and ultimately, wherever the cases are taking place, they do refer back to international courts for guidance. Editing the updating manual was not a small task. Checking the jurisprudence, ensuring that everything was up to date. The decisions are constantly evolving, and this is why the manual has been carefully updated over several years, and it's hoped that in the future, the manual can continue to be updated to incorporate the ever-changing practice and jurisprudence. As I said earlier, we want to give a big thanks to everybody that helped with this, that gave the time for free for the updated manual, and without them, it simply would not have been possible. So thank you to everybody. I don't know if, Colin, you've got anything to add on the manual update, old one, new one?
Well, I actually had something to add on an entirely different topic, but it's related. If that's all right, and I hope that this is the appropriate time to do it. When you go onto the ADC-ICT website, you will see in the upper menu the word store. And this refers to a website that is called The Hague Shop, all in one word, thehageshop.com, www.thehageshop.com, I guess. And this is a website that was started by lawyers and then one filmmaker. It has products that are related to the international law, and specifically, though, the ADC. So coffee cups, shirts. Now we have a new set of T-shirts that are coming out that lawyers maybe will appreciate, because we're making fun of some of our Latin phrases that we use in the law. There's also covers, sleeves for computers, and covers for phones. I don't want to belabor the products, but this was put together as a means to raise money for the ADC, which gets a percentage of all the profits. So while this may seem a horribly brazen commercial pitch for the Hague Shop, that's exactly what it is. And the holidays are coming up. If you want to buy something for yourself or for a friend, remember, if you do it here, it'll contribute to the ADC. And that's, again, thehageshop.com. It's just one word. Or go to the ADC and click on store. And we hope that you enjoy some of that. And then next time we'll be in even better position to fund our next update on our manual, which we hope will be continuing into the future.
Maybe I should add, I'm just looking at the list of participants, and there's a lot of unfamiliar people, which is really great that you're spending your Saturday afternoon with us. But maybe just to give a brief history of the ADC for those that are not aware. We're the only organization that's officially recognized and membership's compulsory to be on the list of council, formerly at the ICTY and now at the mechanism. It was established in 2002, so a good 9 years after the establishment of the ICTY. The judges felt there was a need for some defense body to regulate defense counsel on things like disciplinary, to ensure that there was efficient, effective representation of the accused. So we're in the rules of procedure and evidence. Membership is compulsory for anybody on the list of counsel, formerly at the ICTY and again at the mechanism. We're involved in the rule amendment changes equal to the prosecution and the registry. We're involved in disciplinary mechanisms, consultations on policies, whether that's legal aid or anything to do with that affects the function of defense. And then we also have a separate role to the wider legal community on training, outreach, and we usually do regular trainings once per month. Of course, this year we've not been able to do it in person, and this whole online is somewhat different when you're trying to teach advocacy skills. And the annual mock trial that we do is hugely popular, and we do it in the courtroom of the mechanism, which is not been possible, unfortunately, this year. Again, the annual conference we normally hold attracts a lot of interest. We ordinarily would have been holding it today. We'd advertised back in January, the title, everything was planned, and yeah, events of 2020 took over. But membership of the ADC is open to everybody, including those that are not legally qualified. They can become affiliate members. If you're interested, you can either email me or go to the website where there's full information. But yeah, the ADC basically is de facto the defense office at the mechanism without having the official recognition as defense office, but we're fully integrated into the work of the mechanism to represent defense interests. And I see we've got a question. You mentioned country, this is a question that's just come up on the chat. You mentioned countries using it for training outside of the former Yugoslavia. What are the hopes for the future of the manual, and what do you need to realize these goals?
Wow. I think...
You want to touch on that one, Colleen?
The hopes for the manual is that it becomes a broader and broader practical resource for lawyers. For example, as Don was discussing, we added a chapter on contempt this year, which had not existed before because contempt became an issue and the manner in which it was being prosecuted. So the hopes for the manual is that we can continue to make it a valuable resource for lawyers around the world. And lawyers around the world are learning international law. For example, the new Kosovo Specialist Chambers, although it says it's a Kosovo court, the Constitution of Kosovo incorporates international criminal law. How much this works in every other country in the world, I don't know, because I'm not in any way an expert on the topic. But I know that the jurisprudence from the ICTY and the kinds of discussions that are in the manual, for example, this is how you present an effective oral argument, or this is how you present a persuasive written motion. This kind of thing undoubtedly relates to almost any area or kind of criminal system in the world, to the extent that defense attorneys, or any practitioner for that matter, can benefit from having those skills and thinking about those skills. And of course, the manual doesn't say everything. There are things we may have left out. There are things that people may disagree with. But at minimum, I think it provides a lot of information that's thought-provoking and will be of assistance to lawyers around the world. That's my hope for it. And I think the hope for the ADC as an institution, Dom's mentioned some of the things that we do when we're not awash with COVID. But as an institution, is that we provide ongoing training through a lecture series to new lawyers who are coming into the system, be they already experienced lawyers or brand new lawyers. And we have the mock trial. And you know, there's one thing about the international criminal law system that is important for everyone to realize if you want to practice in the system. Most of the courts require that you have a significant amount of experience as a lawyer before you can be put on a list of defense counsel. Now, where do you get that experience in an international criminal court? Very difficult to find. So the manual can, in some ways, provide information about the structure of these proceedings, and the ADC is providing training. And perhaps my very favorite aspect of the training is the mock trial, whereas, as Dom explains, we had actual ICTY judges who were happy to assist with this. We were in the ICTY courtrooms. The proceedings were filmed. There was training for a week. Then the trial took one day. There's even been discussions of doing 2 days if we can ever convince anyone to stick it out for 2 days with the kindness of the services that were given to us by the people who work within that institution. So that's the future. The future is that we want to continue to do what we're doing. We think we're effective at it. We have a lot of experienced members, and it just would be a shame to have all of that experience evaporate over the next couple of years for whatever reason. So I don't know if that answers your question completely, or maybe too long, but that at least is, I think, our shared hope for the manual. Dom, maybe you have something to add.
I think you kind of covered that one, and they seem happy from what I've just seen on the chat. Is there anybody else with any other questions? Oh, there's another question come in. What is the reaction of the tribunal to the ADC manual if they rejected your first submission? If it is a useful tool, can they make it part of the legacy projects?
I can try that if you like. I don't want to be monopolizing your time, though, Dom.
Like on the recent edition, we had no reactions. I think in the intervening years between the publication of the first one and the second one, relations with the tribunal have, well, I can say definitely from when I arrived in 2009-10, the relationship between the ADC and the mechanism, or the ICTY, same as, I'd say, vastly improved. For example, we're invited to most of the outreach events. We're involved in publicity. We're involved in basically anything they're doing. They seem to come to us for involvement with it, which was not the case when I first arrived. When I first arrived, it felt like it was always as having to beg to be involved in things. And these days, it seems there's been some mental change, and they realize that without defense, there wouldn't be a court, there wouldn't be proceedings, and that we are there to assist. We're not there to cause problems. And I think when I first came, there was this tendency to think we were trouble causers. And I think just times made that change. I mean, we're talking over 10, 11 years. And like Colin said, it was even worse before I arrived 11 years ago, that there was no access for defense to pretty much the tribunal at one point. So I think time's just been good to us. And there was no reaction at all when the new manual came out. Like, in fairness, I think they were fully supportive of it.
If I could add something,
Yeah.
As time went by, I think what happened, particularly the manual being one step in many steps, and Dom has mentioned them, which was the defense began to participate in, for example, the Rules Committee and other committees that existed within the ICTY. The manual came out, and I think that it projected in many ways the seriousness of the defense, its organization, its cohesiveness, the extent to which it wanted to perform at highest standard of performance as possible. And I know of judges who keep a copy of the ADC manual in their chambers along with the ICTY manual. I think at the beginning that never would have been contemplated. Now it is. There was also a legacy book which was just published this year about the ICTY legacy as a whole. And of course, I'm forgetting the name of it, but you'll find it rapidly on anything that has to do with the ICTY. Dom, are you looking at a copy in your house? Maybe. The editors on the manual were Karsten Stahn, who's an academic and very much involved in international criminal law issues, but also Judge Aegis, who was president of the mechanism at the time, Serge Brammertz, who was prosecutor, and I was the editor for the defense. I believe that the defense was asked to participate in that for the exact reason that Dom and I have in some ways hopefully clearly summarized, which is that as time went on and the defense was producing these kinds of documents, it became absolutely clear that the defense was a serious organization. And when I say the defense, I mean the ADC. We had a great deal of support from the judges as time went on. And in fact, at the launch of the first manual, which occurred, I think in 2011, the first defense manual, there were many judges who were in attendance for that launch and really applauded the effort, the combined collective effort of the defense lawyers to create this particular, I don't know what you would call it, tool for the defense. So yes, over time, I think this type of thing really enhanced the position of the defense of the tribunal. Dom, by the way, is being extremely polite because, to put some of this in perspective, in the very earliest days of the tribunal, I showed up in 2005, I think, but in the days earlier, the defense counsel were not permitted anywhere, including the cafeteria. There was a small defense room where brave individuals kept a pot of coffee going. No one could eat in the cafeteria. By the time, or use the library, by the way, which is of some interest. By the time I arrived, we all had identifications. And now that was true for everyone who worked at the tribunal. You wore an identification badge around your neck so that the individuals letting you in the building knew that you were properly admitted. But the defense identification had the splendor of a bright red frame around it. And the tribunal was festooned with signs that said, people with red badges not permitted beyond this point. So it was not exactly a welcoming situation in those early years. However, as Dom has pointed out, over time, in fact, the defense, I think, became integral, as it well should have been, in the various processes of the tribunal, which it spared us a lot of pointless animosity, waste of time and money, and other resources that were scarce. And I think that the people who are around that tribunal have come to the conclusion that having an organization like that really is important for an international court, such as the ICTY, certainly.
And I think just to clarify, the name of the book, Colleen, is Legacies for the International Criminal Tribunal for Former Yugoslavia, a Multidisciplinary Approach, Oxford University Press. And with regards to the signs for the defense, they now say restricted access because when they moved on to the UN badge system, we no longer had red badges, but there is still all the doors blocked to defense. We've got another couple of questions. The first one, foreign defense lawyers from other systems are welcome to represent defendants in the Colombian peace jurisdiction, Colombian special jurisdiction for peace. They don't need a Colombian law degree. Is there any chance to translate the manual into Spanish?
I mean, the only answer to that is yes. You know, we have, I believe, and Dom can correct me, I believe that there are individuals who worked at the ICTY as interns who are now functioning in that court. And I remember that we received inquiries about the manual being translated into Spanish. Of course, our answer to that was absolutely yes. I personally don't know if that's actually happened. You don't either, Don?
Not happened, but yeah, we have got a lot of interns that are judges and staff members of the jurisdiction. And yeah, it is an aim to have it in multiple languages, but of course, funding is just the issue. Translation is not cheap. But yeah, volunteers or anything we can do, or funding for translation, of course, that's the ultimate aim, to have it in multiple languages, French, Spanish as well. The original one was in, as Colleen said, Serbian, Bosnian, Croatian, and Albanian, but that was funded by the UN because it was part of the Legacy project. This version, we've not had the similar funding, and if we can find the funding for Spanish or any other language, of course, like, it would be perfect. So hopefully somewhere down the line it will be.
And that's why I say go to the Hague shop. We're going to be adding new products as time goes by. Check it more than once, and maybe we'll be able to obtain some funding there. But by the way, those of you who are listening, if you know of people who might be interested in a translation project like this, you know how to contact us. You know how to contact Dom, and we absolutely would be thrilled to have this happen.
And following on from that, there's a student listening somewhere that's asked how they can help for the next version. So I think we've just said, like, translation. I don't know whether it's anonymous, so I don't know, but like, yeah, translation, and in the future, yeah, hopefully there'll be more updates to this manual. Definitely. So that's how you can help with the next version.
Yeah, no one should be shy about contacting the ADC. If you have skills or interest in working with us, we are always open to this. And Dom is the man to contact. He's executive head of office, one of the most organized people I've met in my life. And definitely, you know, any interest you have in that, we are open to this. International criminal law, remember, is new. It's been around for how long? 25 years. This is a dynamic legal system that's changing all the time. It's subject to a lot of criticism. It's also done things fairly well, but it's definitely changing. So there's going to be a lot of work as things go on in the future.
No, we've not got any further questions at the minute. Unless anybody's got any comments, questions, feel free to throw them in the questions and answers box. Don't see any coming, Colleen.
Maybe have we answered everyone's questions for all time?
We've answered. Oh no, there's another. Oh no. No, I don't think so.
I will say one other thing about the manual, which is that even if you're not involved ultimately in the practice of criminal law in the international world, this is still a really valuable resource for any lawyer. And I know we just briefly touched on that with someone. It really is. And you know, the civil and common law systems are very, very different in 1,000 different ways. Various civil law systems are very different. Some countries have neither. Some have a mix of both. But I think there's something there for everyone that, like I said, if it doesn't actually perhaps raise an issue of a new skill, at least is thought-provoking. We don't pretend to have all the answers, but we definitely want to have a dialogue.
Colleen, this one, we've got a new question. This one might be interesting for you as counsel on cases. How do you think this sort of animosity impacted proceedings?
Well,
I'm passing that.
now, that is something that we could call a loaded question. I think most proceedings at the ICTY were absolutely normal and had the usual amount of courtroom decorum. But on occasion, there could be animosity if, for example, a lawyer doesn't know how to go about presenting an argument. Or if a lawyer, and by lawyer I mean defense counsel, or if a lawyer is unaware that, for example, they have certain rights or responsibilities that the prosecution perhaps is not providing. And I think I'm not in any way denigrating anyone. I think most of the counsel who worked at the tribunal operated ethically and appropriately, and the judges held very, very, I think, effective, reliable proceedings. The verdicts were, for the most part, very reliable. But oftentimes when people don't know what they're doing, they'll make a mistake. And unfortunately, in a courtroom, the mistakes sometimes, they can be misconstrued as a tactic or something else that may not be the case. And I've seen lawyers get into arguments about this. The cases are complex, they're long, they involve sometimes absolutely new concepts in the application of law. The last thing on earth you want is to throw in with that a little bit of animosity between the parties. It can happen anyway. But I think if parties are skilled in what they're doing, if they read the rules, that can be, for the most part, hopefully eliminated. And actually, I've just reminded myself of another important point in the course of international law, which is we all talk about the system of international law, but please be advised that in its own way, there is no system of international law, although one is developing. And I say that because the rules of procedure and evidence, the ethical codes, the rules that govern the conduct of employees, such as members of the registry, name anything. All of these tribunals have different rules, different focuses. In general, they are the same, but sometimes the specifics can be very, very important. So if you find yourself functioning in a court, make sure you read the rules, you know the rule, you know the statute, make no assumptions about what happens at one court will happen at another. And again, that's something that I'm hoping the manual emphasizes in some ways in the areas where this arises, that despite the same legal issue arising, it can be handled in very, very different ways. And the one that pops to my mind is the admission of evidence. And I don't want to belabor our discussion about manual with a specific, but rules regarding the admission of evidence at trial at the ICC are now quite dramatically different from other tribunals. And it's just one example. These things it's important to pay attention to.
Sorry, Colleen. I'm just checking. I've got another question. Interesting, earlier you mentioned that contempt proceedings are becoming more common. Do you think there is any correlation between this then and what you've described as mistakes being construed as something less innocent?
I don't know how to answer that question. I think there are times when individuals engage in misconduct. That's a fact of life. I've also seen proceedings at the ICTY, and I'm thinking of the Perlich case in particular, where one defense lawyer got into a great deal of trouble about a move he made. He didn't produce certain information for the prosecution. He thought he was completely within his rights. The prosecution thought that information was being hidden. There was a bit of a brouhaha about the whole thing. And ultimately, the Association of Defense Counsel was asked to come in. We have a disciplinary group to come in and look at the situation and advise the court. And the situation was resolved ultimately by the court, not by the Association of Defense Counsel, in favor of defense counsel. So I think you run the spectrum with this. There may well be people who are not following the rules of court appropriately or engaging in unethical behavior. The vast majority, in my opinion, do not do that. They function as they should. And there are times when there are misunderstandings. And again, that's why, you know, you want to have a fair proceeding for working that out as well.
There is no more questions, but Professor Mike Newton's sending his thanks and suggesting everybody prints and reads the manual rather than merely going under the press of time when faced with a problem. Yeah.
Thank you, Professor. Yes. Good advice. And of course, again, we're not the only resource, but we do think that we're a valuable one, well worth checking out. For that reason, it is offered for free online.
We might have one more question. Oh, no. Sorry, I'm just checking behind the scenes. We've got one more question. Again, the effort of the defense to be recognized as part of the justice effort at the ad hoc tribunals is it showing effective at the new Kosovo specialist chambers?
Which one of us is going to get that one? I mean, the real answer is no one knows.
Nobody knows. It's too soon.
It's too soon. There's been an effort there to organize the defense, which is not yet anywhere near the kind of organization that the ADC has been able to offer. But we'll see. At least the effort is there. I know that the the Kosovo Specialist Chambers has said they recognize the defense group there, but what's still murky, and I think in time it will be sorted out, is exactly what that means with the defense group. It's still fairly amorphous. There's going to be a general assembly with the people who are on the list of counsel there in later on in December, and I'm sure a lot of things will be worked out there. The ADC, of course, has offered its services, its expertise, its background, and you know that may or may not be considered valuable there. It all remains to be seen. Hopefully, we can help.
And one more question. I imagine your manual deals with practical aspects of the work at the ICTY and IRMCT. At the ICC, the court pays for OPCD that provides new defense lawyers with information compiled about all previous ICC jurisprudence about contempt or all previous jurisprudence about disclosure. Does anybody provide something like this at the mechanism?
At the mechanism or at the ICC? Oh, I see. The compilation of jurisprudence. I mean, Don, you may know more about this than me. There's a website where, in theory, you can get to everything that's ever been filed in any case at the ICTY or the mechanism. My experience with it is that it is often difficult to get to specific things unless you really know exactly what you're looking for, the name of a motion, for example. But if you go on the website, you'll see that all the cases that were tried are there. If you click on the name of a case, you will get a drop-down menu that will ask you what it is you're looking for: trial proceedings, indictments, appeals, judgments, and even transcripts. So there is access to that. It's not in the same format as what you're getting at the ICC, because of course the tribunal was there for 20 years and there was a huge amount of litigation. But there is the database there, and you can get to it through their website.
And I think just to add on relevant issues that are pertinent, the ADC has compiled documents such as last year we did one on the early release issues and the whole history of the early release, because that's a big issue for a lot of our members. Obviously, there's a lot of people serving sentences around Europe and now down in Africa. And there's been issues with early release, meeting the 2/3, things like that. We did a whole compilation and provided a big document to all of our members, compiling all the jurisprudence on early release decisions from the start of ICTY, ICTR proceedings, which was for their use. So again, on a basis when something comes up pertinent, the ADC does act and provide its members with jurisprudence on that kind of issue. Of course, nowadays there's not as many trials at the mechanism, but the big issue for us is post-conviction issues as well, which seems to be largely forgotten because they're serving the sentences, but a big part of the mechanism's mandate is to look after those that are serving sentences around, Europe and Africa.
You know, Don reminds me, this doesn't have directly to do with the manual, but it does with the kinds of services and why the ADC was considered valuable by the ICTY, to go back to an earlier question. And that was, we have a disciplinary council, and it isn't directed just toward if someone has a problem, we're there to, participate in analyzing it and figuring out what to do. What the council will do is, if there's a lawyer there that has is concerned they have a problem, that they might run into an ethical issue, that they have some dilemma in their case involving the client, or whatever may arise, they can go to the disciplinary council, who will then issue them a confidential opinion that guides them as best that can occur as to how to handle the situation. And what we've found over the years, and this is where the ADC did become quite valuable to the tribunal, is that we avoided a lot of problems this way. Again, people come from all over the world. One country's idea of ethical behavior in court may be quite different from another country's. Some of the lawyers aren't trained in ethics in the same way. And having that group there to assist really, I think, in the long run, solved a lot of dilemmas, or at minimum, if the dilemma was there and it came up before the registry or a court, there was the association there to say, well, we believe that this is at least one way of looking at the problem. So it was another voice added among people who actually practice law and actually have these kinds of dilemmas, for the benefit and the assistance of whoever it was who had to resolve those situations.
As far as I can see, we've got we've got one, but it's not a question. Thank you. And thank you to Mike Newton. It's from Marie O'Leary, Vice President and former Head of Office of the ADC. I can't describe how fabulous resource it is for all practicing to say, and happy you gave your precious time to update it. And thank you to all the students at Vanderbilt University for their efforts.
Yeah, all I can do is say bravo. And endorse that. Thank you very much, Vanderbilt. You really made a difference in us being able to produce this manual at this point, the update. Truly appreciated.
Yep. So I think that concludes this afternoon's session. Thank you to everybody for spending the time with us. Hopefully you'll read the manual, find it useful. And as we were talking about the ADC, in 7 minutes time, we've got the annual General Assembly after this. So any full members that are online and watching, stay on this link. Everybody else, well, thank you for your time. And again, if there's anything you want us for assistance with, the ADC anything, feel free to email me anytime I'm available. But thank you again for giving your time and joining us this afternoon.
And good luck with your future careers.
Yeah. Bye, everybody.